But in this case, the issue has already been decided by this honorable court. And your lordship may kindly see my IAM. I have annexed the order now. At page number 13, my lord. The operative part, your lordship may kindly turn to page 20, my lord. Paragraph 23, my lord. By applying the judgment of the Supreme Court in the case of Union Territory of Ladakh, this court held that it was bound to follow the earlier judgment of the Supreme Court.
Yes.
TRF.
Yes, responded, but yes.
My lord, the order dated, my lord, against which, my lord, by which, my lord, it was annexed, my lord, as annexer to, my lord. My lord, honorable, this honorable court has heard this matter, and my lord, passed this order in view of the, my lord, I'm reading case 23, my lord.
20,
23, my lord, IA.
then the page 20.
IA, my lord, then, my lord. Page 20, yes, my lord. In my thing, it's 23. 20, my lord. 20, in view of para 25, my lord. In view of the reasons stated above, the arbitral tribunal constituted by the railway in terms of the letter dated 30/10/2023. Oh, sorry. What? Wait, my lord. It's order, my lord. At page 12, my lord. 11, 12, my lord. My lord. I'll read from page 11, my lord. Last para. On the other hand, page 11, my lord. On the other hand, Mr. G. Goswami, Thane Standing Council, Railway submits that in view of the decision of the Honorable Supreme Court in Central Organization for Railway Electrification versus so and so, reported in 2020-14 SCC 712, and in Rajasthan Small Industrial Corporation Limited versus MS Ganesh Containers, reported in 2019-3 SCC 282.
So what do you say about the order at page number 38?
My lord, thing is this, my lord, by this order, my lord, it is the Honorable Court has said that the central organization,
After the decision.
my lord, yes, my lord, and my lord, lordship will find, my lord, this is the order, my lord. My lord,
Which order?
in central organization, which was referred to, my lord, larger banks, my lord.
No, that we know that has already been heard and reserved.
And
Now we are
reserved, my
waiting
lord.
for the judgment.
Yes, my lord. So, my lord, it will be out by 10, before 10.
How do you know that?
My lord, because honorable, my lord is in this, my lord, my lord. That is why, my lord, that is my.
All right, Mr. Hussain.
My lord,
Yes,
subject
my
to correction by.
My lord, there is another judgment of the Honorable Supreme
No,
Court.
that's all right. He's pointed out something that
Yes.
the coordinate bench had earlier ordered that it matter be listed after the decision of the larger
Yes,
bench.
yes.
So you have not prayed for a review or
Yes, exactly.
challenge or anything
Yes.
like that. So
Yeah.
let us keep it after 15th of November.
Yes,
My lord, can it be on 20, after 20th, my lord? I will be out
On
on 15 to
26,
21.
other matter has been fixed by your lordship on 20.
My lord,
26.
26. My lord.
All right. It is submitted that by Mr. R. Hussain in the IE that the issues involved in the matter similar writ petition. Similar arbitration petition has been disposed of by coordinate bench by order dated 18/6/2024. He has referred to copy enclosed in 2 the IA. It is submitted that the coordinate bench has already appointed the coordinate bench by the said order and appointed an arbitrator in the matter, notwithstanding the pendency of the decision of the larger bench in the apex court in notwithstanding the pendency of the decision in Central Organization for Railway Establishment versus measures ECISP, so on page number 18 by the larger bench. So, there are Mr. G. Sharma, learned counsel appearing for the railways on the other end, has referred to the order dated 28/11/2022. State the present arbitration petition. This is arbitration petition
18, my lord.
18, wherein coordinate bench had earlier passed the order taking note of the pendency of the decision of the larger bench in Central Organization for Railway Electrification, that the present matter be listed after the decision by the larger bench is arrived. So, this order has not been, this order still remains. So, accordingly, this court is of the view that the matter be listed again after 2 weeks, permitting both the councils to apprise the court about any decision that may have been rendered by the apex court in respect of the central electrification that matter be listed on 26th of November.
Please, my lord.
Item number 2,
One,
similar.
two,
Hmm?
two also.
2 also same.
Yes.
Right. 1 and 2 same. Any further arguments?
Well, they have filed a written submission in response to our written submission which we have filed. Now, as we find in their written submission, there is nothing new except what they had stated in their counter affidavit. Now, except that, they have relied upon 3 judgments.
Hmm.
At page number 4 of their written submission,
Yes.
they have relied upon 3 judgments.
Yes.
Now, first is Girish Kumar Agarwala versus the Assistant Commissioner of Income Tax.
Hmm.
This we have already dealt with in our written submission. At page 127. to 131. We have already dealt with this. And
Yes.
we have submitted, my lord, that in Girish Kumar Agarwala's case, the first proviso to section 147 was not the issue.
Your lead case was which item?
Mukund Infrastructure Private Limited,
No, no, I know. Which writ petition?
71031.
710. Okay. 710. Yes.
This was the lead case, my lord.
Yes, yes. Written argument. Petitioner. Right. Have you submitted your written arguments?
Yes, my
You
lord.
have.
Yes, in all the cases, we have.
You have submitted a consolidated written argument.
No, separate,
Separate.
separate for each. The issue is same, my lord.
Okay, please, then you are referring to your written argument. Yes.
Yes, my lord. In this Girish Kumar Agarwala's case, we have dealt in at page 117 to 121 of our argument.
Yes. Then
120, 127 to 131. 127 to 131.
so if you want to distinguish,
Huh.
you want to distinguish the judgments,
We have already distinguished in our written submission.
you are only giving the references, or you want to
Uh,
argue, make some more submission.
If your lordship want, I can make.
No, no, it's not about my wanting. Do you want to make any submission? If you think you are completing your arguments, only giving us the references where you have dealt with these cases, we'll
Yes.
note it down.
The
But
only,
beyond that, if you want to make certain submissions, then we'll have to again keep it for some other day.
no other submission.
No other. Then what is the second?
Then the second case, they have relied on Rochana Agarwal. Now, this again is not applicable in our case. I'll just submit a copy of Rochana Agarwal's case.
So this also you have dealt it with your in your written submission.
No, they have mentioned in their written submission for the first time. my lord.
No, then Mr. Agarwal will if you want time, we'll give you time. There's not a problem with this. But today we don't have, we'll not be able to conclude, and then we may not be able to conclude. Therefore, we are just asking you if you want to refer to the judgments and distinguish or make an attempt to distinguish, then you'll require some submissions to be made.
In fact, my lord, the judgments which they have cited, these help us.
I am making it clear that if you want to argue, we are keeping it on a separate date. If you don't, then we are closing the argument. Give me an option.
My lord, this Rachana Agarwal, this supports us.
I am aware of the fact that a lawyer's argument is never done. But nevertheless, we'll have to conclude somewhere.
My lord,
So if you think you want to distinguish the judgment, you'll need time to refer to the court.
I
Refer to the
don't
judge.
want to distinguish. I will just, only few lines I will mention. My Rachana Agarwal, which they have relied upon, it supports us.
Right.
It says, my lord, that the information received from the investigation wing by itself cannot be treated as information. The AO requires to do some investigation. We have already mentioned, my lord, that some independent inquiry is required to be made.
Okay.
In our case, no independent inquiry was made. And the case which they have relied upon, some independent inquiry was made, so therefore that case is not applicable.
Paragraph?
In Rachana Agarwal's case, my lord, I have a copy, paragraph 26, my lord. When we examine the facts of the present case, my lord, keeping into view the scope and power of the judicial review while scrutinizing a notice issued under Section 148, as explained in Raymond Woolens Mills and Fulchand Banjarangla, we find that the notice under Section 148 has been issued by the assessing officer after conducting an investigation and going through the income tax return and other related documents.
You are reading from,
There are 26, my lord.
can you read the beginning, opening line?
When we examine the facts of the present case, it is towards the end, my lord.
Lots of last page of the judgment.
Last page of it. Yes.
When we examine the facts of the present case, am I with you?
Yes.
Your Lordship? Keeping into view the scope of power of judicial review while scrutinizing a notice issued under Section 148 of the Act, as explained in Raymond Woolen Mills case and Fulchand Bajranglal case, we find that the notice under Section 148 of the Act has been issued by the assessing officer after conducting an investigation and going through the income tax return and other related documents of the assessee, and after giving reason to believe that the income amounting rupees itna has escaped assessment in respect of the assessee. My lord, our case is that in our case, no independent inquiry was made
Prior to issuance of notice.
prior to issuance of notice.
Now please come to para 22.
Yes, sir. In the present case, my lord, prior to issuing the notice in question, the assessing officer had not formed any opinion regarding the reasons on which the notice under Section 140 of the Act has been issued, and therefore it is not a case of change of opinion. And the challenge to the notice under Section 148 of the Act on the ground that it seeks to initiate reassessment on the ground of change in opinion cannot be accepted. My lord, here in this case, the assessment was made under Section 143(1). That is a summary assessment which does not require any hearing. In all our cases, assessments were made under Section 143(3) of the Act after giving us opportunity of hearing.
No, what I wanted to point out,
Yes, ma'am.
even in your case, one of the arguments is that it amounts to a change of opinion.
In our case, the argument is that after receipt of the report of the investigation wing, the assessing officer has not applied his independent mind.
He is acted under the behest of that
Yes, ma'am.
authority.
So it was a borrowed satisfaction.
Okay.
Then, my lord, the The third case which they have relied upon is that
This is the alternative remedy.
alternative remedy. Just. It is Chabil Das Agarwal's case. Chabil Das Agarwal, it apex court judgment which they have relied upon. Now, my lord, in Chabil Das Agarwal's case, they had challenged the assessment orders made by way of writ petition. It was not the notice or the reasons recorded which were challenged. After the assessment was made, they have filed a writ petition. Therefore, the Honorable Apex Court has held that once the assessment was completed,
Yes.
then the alternative remedy was available by way of filing of appeal before the first appellate authority, then the tribunal, and then the High Court might.
Yeah.
And my lord, this case of Chabil Das Agarwal has been distinguished by the Honorable Apex Court. My lord, this judgment has been distinguished by the Honorable Apex Court itself in Jeans Writ case, which I have already filed in my compilation.
You can refer the name of the judgment.
It is Jeans Knit Private Limited.
Can you spell out?
Yes, my lord. Jeans, 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 KNIT, Knit,
ANIT.
KNIT, Private Limited versus DCIT.
It is reported in
It is reported in 2017 to 390 ITR 10.
390.
390 ITR 10. It is a serial number 33 of my compilation, which I put.
Okay.
That's all, sir.
Heard the counsel's parties and the hearing is concluded. Judgment reserved.
Macham.
Yeah. Thank you. File or anything. Yes.
May it please. My lord, I beg to submit, my lord, may take up the IA that we have filed on that day,
3290.
3290.
Yes.
And the new thing that why we have filed this IA is that on 5th of November, STS called for an examination interview for the post of assistant registrar again. And then 3 anticipated vacancies and 3 candidates have been called for, bearing us. So in first occasion, your lordship has permitted us to appear, but we failed to get selected. But this time, my lord, they have not again included my name. That is why this IM. My lord,
Is your appointment or promotion order available here in the IA?
pardon?
Is your order promoting or appointing you to the post of court officer
That is in the main writ petition.
main writ. Let us have a look at that first.
My lord.
Here, page number.
My lord, at page 18 and Annex 3. The last paragraph of this notification, that is causing trouble. And this last paragraph has been declared redundant by a division bench judgment.
Now, he was appointed as a senior judicial assistant.
Yes. Then he
Then-
got promoted to the post of court officer by this notification, by this appointment.
He was appointed.
Appointment.
He is holding the post of court officer.
Now court officer.
And what
That is-
happened? What happened to the vacancy which arose in from his original vacancy?
That was filled up on 20 July 2017. This is what the observation made in the division bench.
And that has traveled to the Supreme Court and it was dismissed.
It was this.
So the position is attained finally.
My lord, only thing, my lord, you can make it cut short, my lord. I got one instruction from the registry, my lord. We don't have objection if similar order to the earlier order.
No, but why, if you don't have objection, why don't you issue a corrigendum and invite, give him an opportunity to
My
participate?
lord, my lord, actually, all of them are our employee, my lord. But
Hmm.
there is,
Where is that notification by which others have been called and you have been left out?
My lord, it's 3290 IML.
You want to say something?
That was allowed earlier.
no,
We'll see about that. Yeah. Where is that? Where is that list? Where is that notification?
My lord, I'm sorry.
my. Mr. Bean, huh?
Annex
Mr.
B.
Bean,
Annex
page
B,
17.
page 17.
Hmm?
Page 17, my lord.
One
Page-
seven.
Page 17. In the IA 3290.
One.
This last interview for the post of.
Why was he left out? Oh, he's. No. Page 17.
Page 17.
17 is his appointment to the
No.
post of court officer.
No, Lordship is looking at the IA, my lord,
I am, my lord.
3290.
Page 17.
17. Last paragraph.
Yes.
There are 3 anticipated vacancies, if Lordship can see in the first paragraph. And only 3 persons have been called for.
3%.
Yes. No, sorry, 5 persons have been.
For one vacant post of joint registrar, one clear vacancy,
sorry,
two
sorry.
anticipated deputy registrar, three anticipated assistant registrar. You
No,
read that?
I'm so sorry, my lord. They called 10 persons. Sorry.
What?
10 persons. I stand corrected.
For the post of assistant registrar.
Assistant. 3 anticipated vacancies. Actually, they should have called, to my information, 15%. Because 1:5.
One is to,
To my information, they should call 1:5.
no, your information means, is it not reflected in the rules?
My lord,
So was
actually,
the provision of the rule.
rules, my lord, there's another limbo of argument is this, that the High Court stand is that there is a rule called 7(4). Rule 7, sub rule 4, which was notified in the year 2015. Actually, that rule does not exist. Though it was notified, it was not exist, it was not included in the rules because of the fact that there is already a rule 7(4). If your lordship would like to see that, I can show it.
No, you are saying that this is 1:5.
That is that rule, that is what I'm saying, my lord.
So
That rule 7(4) that my learned senior friend and the registry is relying upon, they have annexed that notification in the affidavit in opposition. Notification dated for 24/7/2015. That is at page 65 of the writ petition. This notification is wrongly issued, means to the effect that it should not have been rule 7(4). Why don't you see, rule 7(4) is something different.
My lord, common practice is this, 1:4, ma'am.
Maybe 1:4. I stand corrected. That is why I'm said to my
common practice has to develop from some.
My lord, as per all other rules, my lord, 1:4. If there is one post, 4 candidate will be called.
Some decision somewhere has to be taken.
Yes, ma'am.
My lord, kindly see that page, my lord. Page 640, my lord. And page 643 of that brown cover book. Page 643,
7(4).
this is 7(4). The post of chief translator, senior grade translator, so and so, so.
What about the post of extended registrar?
This is again that notification. If lordship can see it, the page 65 of the writ petition. This is the notification relied by the, not exactly writ petition, of affidavit in opposition filed by the registry. Page 65. This rule, though it is notified, it was never included in the rules. It was never published by any book. And this cannot be rule 7(4).
No, then you have to challenge it. Have you challenged this rule?
No, but nobody knows about this rule because
You
book
know
says,
now it has come to your knowledge by way of the affidavit.
no, you file a reply, my lord. In reply, you have stated all this.
If you say that this rule is not there or it's not in existence, you have to you have to pray for an order for setting
we can-
aside or
Yes,
holding
that,
that this.
that we can do this, my lord. But we have
No,
that.
we are not advising you what.
Understand, my lord, but
But
we did not have the knowledge about this to 2015.
when was this notification? When did this affidavit? When was it filed? 30 July.
It was filed on 30 July.
30 July. So
Yes.
since 30 July, has been brought
But
to
we
you.
have brought it to the notice of this honorable court by filing a reply that this should not have been rule 7(4). Until and unless this has been amended by the registry or by the honorable chief justice, then this cannot be given effect to, because rule 7(4) is already there.
It does not replace. It says the following sub rule is added.
Well, how can there be 2(7)(4)?
Why? What is the wrong there? There is already an existing 7(4).
Hmm.
By this amendment, this particular part is added to that already existing part.
No, my lord, this is not like this, my lord.
I don't know. This
When
is what it
there is
says.
a rule 7(4), again, if there is another rule 7(4), without either they have to buy in this same notification, the previous rule 7(4) has to be deleted.
No, but assuming this nomenclature is incorrect, does it mean that the rule does not exist?
Yes, my lord, to my respectful submission,
How?
because if it is not, it's rightly numbered,
Hmm.
so it cannot be given effect to, because if they are saying in notification, they are saying rule 7.4 is this. In notification dated 24/7/15, and there is already a rule 7.4, then which one will be taken effect, given effect to? So, my lord, what my respectful submission is, my lord, looking at uh, uh, the exigency of service, my lord may allow us to appear, my lord, as my learned senior friend has agreed to, and put it for a hearing, my lord. Will apprise this honorable court.
Yes, Mr. Boyso, what is the stand of the registry here?
My lord, as it appears, the rules is not clear. Everything is jumbled. And our stand by the affidavit in opposition that there is existing a rule 7.4.
No, let us understand let us come to the schedule of this book.
Yes.
This is class 2A, extend register,
Yes,
page number 664,
yes, ma'am. Class 2A, ma'am.
class 2A.
Yeah.
So this class 2A will be under rule 11. Where is the promotion
My
Yeah.
lord,
rule?
rule is not exhausted, my lord.
Huh?
That is the main difficulty.
There is no rule which says that you'll be promoted.
There are, my lord, judges committee's decision, my lord. Resolutions
Where are they?
that are not in my custody.
We have annexed it in our
If it repeat, there are some,
in our affidavit in opposition.
No, you
My
are.
lord, my lord,
Yes.
the rules
One
is
minute, 1 minute. Mr. Omua,
Well-
what is your claim? Hello, people. What is your claim?
claim is that, my lord, after passing of this division bench suspension,
Hmm.
when division bench said that while the post I left behind is filled up, so there is no point going back, or there is no scope that I am going back to my original cadre. Since it is a promotional post and a substantive post I am occupying as a court officer. Therefore, my according to the affidavit also, I can show from the records that there are 3 posts in 2 cadres which constitute a consolidated cadre, and they are maintaining a inter seniority in that.
You are aggrieved by what now?
I am aggrieved by, initially I was aggrieved by that I was not allowed to participate in the examination
Yes,
for the extended post,
right.
because post of court officer is a feeder cadre to the post of extended.
How do you say that?
This is from the schedule, my lord.
Where is that provision?
page 640. 7 sub-rule 3.
The assistant registrar shall be appointed from among the state judicial service grade 3 or by promotion from among the gazetted officers of the High Court services belonging to class 2B, class 2C or class 2D. And court officer is class 2C. Yes, class 2C. Roman 3. And in the schedule 665. Page 665. Roman 3.
And what is the ground for not giving him the notice to participate?
Grounds has not been communicated.
Huh?
Grounds, I asked for instruction. That instruction I have received in the eye. And on earlier occasion, our stand was that he doesn't come in the zone of consideration because his seniority maintained in the SJ
No,
cadre.
but that is pursuant to the division bench judgment. It is applicable to him also,
My lord. And
unless you
and-
say that
and-
the post is kept vacant.
Exactly, my lord. And at the same time, we have taken a stand that the rule is under active consideration for amendment.
So don't proceed with the promotion.
So the thing is pending, my lord. As nothing concrete has come up.
In concrete, then why are you going for promotion? If you do not know what rules will apply, who will be promoted, then what is the purpose of having a set of rules which you say that doesn't give you anything?
Well, we have, so far my inspection mandate, we have no objection if similar to the earlier order.
No, no, that is an interim order. I'm
My lord,
asking you why repeatedly,
the
why
case,
repeatedly you are going through the same process.
the case may be kept pending and that is there, man. Yes, man.
Why repeatedly you are going ahead if you are not ready for the, you have to tell us whether the see, subject to correction, perhaps the court officer, court master, then protocol officer, all these posts are more, although promotion or also separate cadre, more in the nature of being deputy.
My lord. And the division
And
bench,
therefore their seniority is maintained in their original feeder cadre.
my lord.
So that in the event they don't perform properly, they get be sent back.
Exactly.
But then
That is the
how-
purpose.
no, if that purpose is there, then why do you fill up
The vacancies they
original
left.
vacancies? Where will they go now?
My lord. Very true, my lord. And kindly consider the paragraph 67 of the division bench judgment. The division bench has stated that these are very demanding posts, my lord, with great responsibility. And when a person is appointed as High Court Judge Secretary, these are very confidential.
No, secretary to the Honorable Chief Justice's office, different cadre.
My
entirely
lord, my lord, my
different.
lord.
Here on
My-
the post of a court office.
Yes, my lord. And
Your rules say that he falls under category class.
to see, yes, my lord. And only there are
Is
two
there,
posts.
is there any requirement of number of years to be put in?
No, no, man, not such.
Huh?
The rule says only assistant registrar shall be appointed from amongst the state judicial services grade 3 or by promotion from the among the gazetted officers of the High Court service belonging to class 2B, class 2C or class 2D or from among advocates of not less than 5 years continuous practice at the bar. This much. So there is nothing this sort that he has to be a court officer for 2 years or 1 year, then only he can be considered. Not like that. And the rule is seniority come merit.
You come back tomorrow with your instructions, why we should not say this? You don't have any rule. Why are you going for promotion? You set your rules, set your house in order first, then go. You do not know who comes from which feeder gather and who will go where.
Yes, ma'am.
The last occasion also I recollect you were not posted with the instructions.
Ma'am.
Today also you are not posted with instructions except this.
Except that one.
Then
My lord,
the sorry state of affairs. I'm sorry.
my lord, actually, I don't know. This is the instruction that has been provided.
But your expertise in respect of the rules
My lord.
are expected by this court. You must tell us what indicate, what does it say, instructions apart. You have to tell us the rules.
My lord,
You have to tell us the rules vis-a-vis the judgment of the division bench.
in that matter, my lord, affidavit in opposition may be taken up. Right? My lord, as per page 65, annexure A4,
That is the rule you have
yes, my lord.
said.
And as per these rules,
So
my
what
lord,
does it say?
it says that the post of court officer in the principal seat of the Guwahati High Court and the Kohima bench shall be filled up by calling options from administrative officer AO, judicial, and the senior judicial assistant. The persons so appointed in the post of court officers shall maintain their respective seniority in their original cadres, that is the cadre of administrative member, judicial, senior judicial assistant, and their further promotion will be considered on that basis. So,
Mr. Somo, this is not on the challenge.
no, my lord.
Not, we have come to know later on only, while this
Later on,
was
6 months has almost gone by.
not.
We are
In
about to be in November.
October, my lord.
You have to tell it this. Right or wrong, there is a set of rules. And the rules say that your seniority will be with effect from the
My lord,
Either-
by the judgment of the division bench, this has already been redundant.
but that has to be challenged first.
My lord,
Who has put this under challenge?
My
Division
lord-
bench judgment did not consider this rule. This rule was not put to challenge before the division bench.
but the by application of law, my lord.
No. You have to be clear. Division bench said division bench judgment has only held the question of seniority. Whether his seniority will be counted from the leader cadre or in his existing, and when, from which date. So if his seniority is to be maintained in his leader cadre, and the division bench proceeded to hold that perhaps in case he was not
No, my lord,
satisfied, he can be remanded back.
what I am trying to impress upon your lordship is this, that the language used in this notification, I will not say it as a rules because this 7-4 rule is already there.
The
This-
language used in the rule is shall be filled up by calling options from administrative officer.
My lord, again, this notification contradicts page 640, sub-rule 3. Kindly say.
No, you fall under which category? First tell us.
Pardon me, lord.
In this page 65,
My lord.
what is the criteria prescribed?
I was the
SJ.
SJ.
Senior judicial assistant.
SJA.
A, man.
Yes. Then
Then
four
I
posts-
opted for the option
Posts of
court
court
officer.
officer,
And I was selected, I was interviewed and selected. There is no question as regard my selection and appointed as a court officer is not there. Then nobody has challenged it. That is
Right.
not in question. Question is whether that rider given in the appointment order will survive after the passing of the division bench. This is the only issue. my lord.
no, but for this, at least this has to be brought on record.
My
by
my lord,
challenging it.
with these lordships, what has fallen from your lordship's mouth, my lord, we'll look into it and we'll file a separate petition challenging it. Because as of now, right now, it has catch my notice, my lord. This sub-rule notification dated 24 July 15 is also contradicts the provision in section 3, sub-rule 3,
Sub-rule 3 of
sub-rule 3 of rule 7. Page 640. This was framed, this notification was framed without consulting sub-rule 3. A assistant registrar shall be appointed from among the state judicial service grade 3 promotion, grade class 2B, class 2C, class 2D. But there is nothing mentioned in this notification. It has been tried to be overridden the sub-rule 3. And this is not a non-obstante clause. The notification is not a non-obstante clause. I mean, like
what are your prayers 4 and 5 in the writ petition? This prayer 4 and 5.
my lord, actually, this is a conditional prayer, actually. That if he is appointed to the post of assistant registrar, then my lord, he's on being selected.
You are not even born into the cadre, and you are praying for.
No, my lord, this is
Giving you
actually
benefit.
this should have been an alternate prayer. That
No, no, how can it be alternate? As on date, you are not born into the cadre of.
I understand that, my lord. if Lordship permits me to appear and I am selected, then my lord,
then the course of action would be different. The course of action here is that your seniority is taken from
no, my lord, what my
the-
respectful submission,
your seniority maintained in SJ is taken for consideration the post of extend
extend
registrar
this.
from your header from your post of court of. Now, as per the seniority, he does not fall into the zone of consideration.
Exactly. That
No,
is the
no,
understanding.
my lord, what is my, if I can show it from the record. They have to prepare a consolidated seniority list, inter-se seniority. And in that consolidated inter-se seniority, I am at the top. Let them
Consolidated
consolidate
price
for
of-
these three groups.
Ah.
AOJ, protocol officer and court officer.
Yes.
If this inter-se seniority gradation list is prepared with consolidated, taking all the cadres,
Hmm.
then my lord, I am at the top. Because the judgment of the division bench, if that effects to 20 July 2007. I was deprived of having an
But
opportunity.
no, but then in your case, there has to be an order passed.
I understand, madam. My respectful submission
So
is,
you are saying that you are at the top.
no,
If the principle of the division bench judgment or the ratio of the division bench judgment is applied,
my lord.
that is your sub.
Yes, my lord. And now, my lord, if I am
Now,
during
what
the,
is your
now,
what is your
during the
position?
pendency of the writ petition,
Ah.
at the indulgence of your lordship, I have appeared in the examination, I am selected for a moment. Then, my lord, the inter-se seniority list in the assistant register cadre, if I am got selected, then, my lord, there has to be prepared it newly. Because of the fact that I was deprived of appearing in the examination for assistant register post since,
We'll make it subject to outcome of the writ petition.
yes, that is okay, my lord. The earlier also lordship has
No,
said.
we are not inclined to give you an interim order this time. What is the point? What benefit will you get by participating unless your seniority or your position is determined? This is a waste of time.
That is what the whole writ petition is all about.
So we'll have to determine it. And therefore, whatever selection takes place will be subject to the outcome of the writ petition.
This will affect all the candidates. my lord.
It may affect, we don't know.
Then again, there will be third party rights.
Maybe. But unless we first decide your question of seniority, the very basis of your claim derives from the claim of seniority. Your claim of seniority is in view of this division bench judgment. Your seniority has to be given with effect from a particular cutoff date.
My lord.
That, according to you, has not been done. If that would have been given effect to,
May I take your lordship just one page? This, if lordship gives me 1 minute. Just 1 minute. This is a affidavit filed by them. What does it say? I'm showing to you. It is at page 77. This is a minutes of the judges committee report. Observation of two honorable judges. Taking this particular case in hand.
what does it say?
After the table I am reading, my lord. Lordship has got a table there. After
Yes.
the table. From a careful examination of the rules 1967, more particularly the post included in class 2C, and we find the post of administrative officer, judicial court officer, and protocol officer belong to the same cadre, that is class 2C. It also prima facie appears that all the three posts incorporated in class 2C carry identical pay scale, are interchangeable in nature, and the materials placed before the committee suggest that the registry has also, from time to time, understood the rules in such a manner. Therefore, going by the edict of the rules, it is apparent that all the posts included in class 2C constituted a composite cadre. However, the same cannot be said for the post of senior judicial assistant, which post apparently is not a part of class 2C cadre. The post of SJA apparently belongs to a different cadre under rules of 1967. It is settled principle in service jurisprudence that inter se seniority of the employees ought to be determined in respect of those candidates who belong to the same cadre. Therefore, the seniority of the employees occupying any of the aforementioned post of class 2C, including the applicant, will have to be determined inter se, the incumbent holding the various posts in class 2C, class 2C cadre, and not in the cadre of SJA, which is not a class 2C post. However, such a recourse would not be permissible in the case in view of the Rule 7(4) of the Rules 1967, which provides this. This is the rules. The quoted below is the 2015 note, which is, it does not exist indeed. These are the clear findings of the Honorable Judges Committee. Therefore, my lord, they ought to have prepared a, following this observations by the Honorable Committee, the registry ought to have prepared a composite list of the inter se seniority. This observation is given in my case even only. Your Lordship can see the page 75. Agenda, consideration of the presentation of representation of data so submitted by.
All right,
JLST.
we'll continue tomorrow.
My lord.
We'll continue tomorrow.
My lord, I have some personal difficulties. That is why I sincerely pray for today. My lord. Lordship, just allow us to participate. Detail order will, Lordship will pass in a
No,
later
no,
date.
like that. You know, you are not here, you ask your colleague to be present.
But they may not be able to lead this. My lord, with this. That is
We'll
why.
examine the matter tomorrow. Beyond court. Right now. Tomorrow we'll continue.
Well, I'm in a, will be in a deep trouble tomorrow if Lordship please say.
Why?
Day after tomorrow, I'll be out of station for a while.
Let it be there tomorrow. We'll see, we'll examine. If required, we'll pass the order on Wednesday when in your presence.
Can it be on Wednesday?
All right.
Sorry,
Wednesday,
yes, Wednesday,
Wednesday, all right.
Wednesday.
Matter
Well-
will be listed again on Wednesday. So, you to possibly